Lord Chief Justice, Vice-Chancellor, Dean, ladies and gentlemen, it is a great privilege for me to be invited to deliver this annual lecture in honour of Lord MacDermott, one of the most eminent alumni of and teachers at this university and a judge of international reputation. Unlike his august successors in the office of Lord Chief Justice of Northern Ireland, as the Pro-Vice-Chancellor has reminded us, he took up that post after, rather than before, becoming a Lord of Appeal in Ordinary in what was surely an upwardly mobile career move. Lord Kerr, last year's MacDermott lecturer, in his felicitous opening remarks acknowledged how daunting it was to follow so long a line of distinguished lawyers to this lectern. I feel no less daunted in following Lord Kerr, not least because whether I appeared before him in the High Court in Belfast, in the House of Lords, or in the Supreme Court, I cannot recollect ever having been the recipient of a judgment in my client's favour. And I, for my part, fear that next year's MacDermott lecturer, whoever he or she may be, will feel absolved from any need to pay any tribute to his or her immediate predecessor. I never had the pleasure of meeting Lord MacDermott, but in 1964, as a recent history graduate converting to law and in search of a sound guide to law's fundamental purpose and principles, I read his Hamlin lectures on the theme Protection from Power under English Law, the epithet English being descriptive of the nature of the law being considered rather than imposing some geographical limitation. They included a prescient chapter on the power of the executive, which looked forward to the modernisation of the supervisory jurisdiction, still at what Professor Sir William Wade has characterised as a low ebb, but whose engagement Lord MacDermott described as work frequently requiring skill of a high order. That Delphic reference apart, Lord MacDermott did not comment on what contribution, if any, lawyers other than judges made to the protection from power which he regarded as an aspect of the rule of law. He contented himself only with the cautious observation that, and I quote, "lawyers as a body are slow to depart from the settled way of things." It is, however, the nature of that contribution which I wish to explore in your company tonight. And while my theme, the advocate's contribution to the rule of law, is intrinsically perennial and knows no boundaries of time or place, my illustrations to provide practical underpinning to otherwise theoretical and rootless musings will be topical. They will focus from a barrister's perspective on recent events in England and Wales, that entity that, for the present at any rate, we can still describe as part, but not the whole, of Great Britain. Rudyard Kipling penned the line, "What do they know of England who only England know?" to which my manifestly inadequate response has to be more at any rate of England than of the world beyond. But at one level, one may appreciate Lord MacDermott's abstinence from the theme. After all, is it not elementary that law, where not made by legislation, primary or secondary, or in the exercise of the ever-diminishing prerogative powers, is made by judges and not by those who argue cases before them? But that is surely not the whole picture. In a letter to the Times on the 10th of February this year, the chairman of the English Bar Council, sundry heads of bar associations, and a single female pupil barrister, the inclusion of the latter being a somewhat transparent forensic tactic, the signatories fulminated, as the Lord Chancellor finalises plans to cut legal aid even further, barristers are coming to voice a unified opposition to changes which, if implemented, would have a devastating effect on the public's access to justice and the rule of law, the initials in the latter phrase being given for emphasis capital letters. One is tempted to comment, if a little unfairly, that adapting Mandy Rice Davis's legendary riposte when told that Lord Astor denied having an affair with her, well, they would say that, wouldn't they? It requires no particularly penetrating insight to note that there will also be a devastating effect on council's fees where dependent on the public purse and on their expectations, whether legitimate or otherwise, of a certain standard of living, whatever that might be. On the 11th of July last year, in an earlier and more measured response, as befits the Second Chamber, Baroness Deach, chair of the Legal Services Board, introduced a motion to take note of the effects of cuts in legal aid funding on the justice system in England and Wales. She ended her speech by saying she was, and I quote, convinced that the protection of the profession and of the public that is enshrined in Section 1 of the Legal Services Act will be undermined by the proposals of the Ministry of Justice as they stand. There was scarcely any speaker who did not invoke the concept of the rule of law to justify their assault on the government's proposals. The debate between the Ministry and the Bar Council has been played out in the public eye. The Justice Secretary wishes to cut £200 million from the legal aid budget by 2018 to 19. He claims that expenditure on legal aid is in relative terms higher than in countries of equivalent size and standing. The Bar Council accuse him of dodgy dossiers, in which the earnings of the few so-called fat cats are trumpeted to distract attention from the multitude of starving kittens. One Queen's Counsel went so far as to argue that he should be charged with furthering his career by making false statements in contravention of Section 2 of the Fraud Act of 2006. But into that debate I shall not enter, save to say the Bar Council seems to have currently the better of the general argument, since Sir Andrew Dilnot, head of the United Kingdom Statistics Authority, has warned the Ministry that its figures, and I quote, were indeed calculated to mislead. The resistance of the profession to the proposed diminution in public funding came to a head when barristers declined either to defend alleged fraudsters whose cases fell within the category of so-called very high-cost cases in response to the government's threat to impose cuts of 30% on top of a series of previous reductions, or to accept briefs for cases where colleagues were double-booked, so-called returns. They intensified that resistance with a day of strikes in January and a second round in March, the efficacy of the former only being somewhat impaired by the fact that one of a cohort of young female barristers carefully posed for the mandatory press photograph was carrying a Louis Vuitton handbag. Just last week, the Justice Secretary agreed to postpone the implementation of the savings until after the election in 2015, a truce, if not an armistice. Not this year, but next year, which could mean, depending on the vagaries of the public vote, sometimes, but not, I suspect, never. To put these controversies over remuneration into some context, I read in a recent biography of Thomas Scrutton, the great commercial judge, that the bar in the late Victorian era, well before the notion of legal aid was even a glimmer in the governmental eye, fashionable leaders were paid a brief fee, whether or not they actually appeared in court. Oh, happy days. And the reference in law reports to juniors accompanied by the parentheses with Mr. X Queen's Counsel actually meant not infrequently without Mr. X Queen's Counsel. But are the references, whether in the Times letter or in the House of Lords debate, a mere rhetorical flourish? Or would the extension of the professional advocate to press the point to its limits actually threaten the rule of law, a Prettian concept which I shall use in the narrower sense of ensuring that justice is done according to law rather than in the broader sense of ensuring that the law itself is just? And if so, why? Well, let me start with a statement so obvious that it is often overlooked. While legal giants may debate whether hard cases make bad law, what is beyond argument is that it is cases that make law. Disputes about what the law on a particular issue is or should be, the stuff of academic commentary or of mooting competitions. Nonetheless, until some litigant, sometimes on the advice of counsel, sometimes against it, chooses to bring the matter to court, the issue will be undecided. I have here omitted reference to the litigant in the dock who lacks that essential element of choice. And the cases so brought have to reflect real issues. Our civil courts will only exceptionally grant declaratory judgments about whether some person's conduct, actual or anticipated, would violate the law of the land, if the question is likely to become before a fortiori is actually before the criminal courts. In private law, it's well established the courts will not decide hypothetical cases. And even in public law, where there's been some relaxation of that stern rule, as Lord Slynn put it in the case of ex parte Salem, appeals which are academic between the parties should not be heard unless there's a good reason in the public interest for doing so. It is no part, in short, of the judge's role to give unsolicited advisory opinions. And there are related restraints on what can or cannot be the subject of adjudication at the highest level. The Supreme Court nowadays has almost complete control over its docket, but it can only select from cases contested before the lower courts and in which there's an application for permission to appeal, and even then, for the most part, maintains the traditional practice that it will not decide points which counsel has not argued. In short, judges consume what the advocate cooks. And advocates need not merely serve up a table d'hôte or even a standard a la carte menu. They can be more creative. Two of what are now the standard interlocutory remedies in private law, the Moreva injunction and the Anton Pillar order, were both the inventions of counsel in the respective cases which bear the remedy's name. In the former, Lord Denning said Mr. Ricks, later a senior judge in the Court of Appeal, has been very helpful. In the latter, the same Lord Denning attributed credit, or as he said with uncharacteristic caution, responsibility to Hugh Laddie, later a High Court judge in the Chancery Division. When these developments of the jurisdiction to grant injunctive relief were once sought in association, they permitted one traditionally educated judge elegantly to make a classical pun by speaking of piling pillar on Moreva, in lieu, as you will of course all be aware, of piling Pelion on Ossa, which described in the Greek myth the use made of these mountains by the giants Otus and Ephialtes to storm Olympus. Since the use of Latin in our courts is now frowned upon, such gratuitous displays of judicial scholarship are, alas, unlikely to be repeated. And even if sometimes an advocate seems to bend the bow too far and provoke astringent judicial observations about his fertile mind, on a par with the phrase, with the greatest respect, which in the court context means its exact opposite, in other instances the fertility has borne palatable fruit. Ridge and Baldwin stands out as one of the major cases which started to reshape public law in the swinging 60s, and where Lord Reid was able to chart how once lively concepts of natural justice had been diverted into a dark tunnel, but could now be exposed again to light. But it was Desmond Ackner, Queen's Counsel, whose submissions, as the law report reveals, helped shape Lord Reid's speech. At the other end of the scale, one may instance Lord Nichols' magisterial clarification of the law resulting trusts in the Privy Council in an appeal from Brunei, where I was counsel for the victorious appellant, but where the most charitable reading of the summary of my submissions could discern no visible connection between them and the advice given by the Board to Her Majesty. Indeed, I confess to this audience that there was none. These examples, whether of the sublime or of the ridiculous, remind one of another important matter. In England, the adversarial process, even in the highest courts, is essentially, if not exclusively, an oral process. We've not yet replicated the procedures of the United States Supreme Court, where advocates are conventionally limited to half an hour, with no injury time, for the frequent interruptions usually caused by the justices arguing amongst themselves. Still less have we replicated the processes of the European Court of Justice, where the only golden rule is the proceedings must conclude in time for a leisurely lunch, and the pre-hearing courtesy meeting in the judges' chambers resembles a bazaar in which the president of the court will seek to bargain down the half hour presumptively allotted to each of the lawyers. And even in Singapore, a noted custodian of the colonial legal tradition and an appellate judge, Justice Roger, recently noted in an argument about whether overseas counsel should be admitted to plead a case, the appellate process in the Singapore Court of Appeal has evolved to be more writing-centred than that in many other common law systems. It would be too austere to conclude that written submissions do not equate to advocacy, but nonetheless it is surely the dialogue between bench and bar, which gives oral advocacy not only its savour but its strength. For in the classic adversarial system, it is appreciated that it is out of the clash of submissions that judgments will be fashioned. Lord Eldon, twice Lord Chancellor in the early 19th century, and for an unrivalled period of 26 years, said, "Truth is best discovered by powerful statements on both sides of the question," though, as is well known, he sometimes took an unconscionable amount of time to decide what the truth was. The essay on him in the Dictionary of National Biography refers to the arrears with which he was constantly reproached, an odd literary epitaph for someone whose maxim was that a lawyer should live like a hermit and work like a horse. Lord Panic, in his keynote address to the Bar Conference last year, put it more amply. The law is best administered by independent judges who hear arguments on both sides of a case before they make up their mind. The advocate exemplifies the valuable principle there is always another point of view, a different perspective, an alternative explanation. And Mr. Justice McGarry, in his judgment in Cordell and Clanfield Properties, more pithily put it, "Argued law is tough law," citing in support a dictum of Justice Hanford of 1409, which he'd excavated from the law books, and which, though in a mixture of medieval French and Latin, loses nothing in translation. "Today, as of old, by good disputing shall the truth be known." And in such a system, in both criminal and civil cases, it is the advocate who decides what material is placed before the court. The common law system is not inquisitorial. The judge can rule on what evidence is or is not admissible, but he cannot compel an advocate to adduce particular evidence, nor can he search out the evidence himself, nor critically must he enter the arena in the way in which he did as an advocate, a habit that in my experience some judges find easier to forswear than others. And when there is a fact-finding body whom the judge must direct, his duty is to sum up the facts and identify the competing arguments, not to find facts or fashion arguments his own. In the Channel Islands, the Tribunal of Fact is constituted by jurats, and the trial judge, an office holder sometimes called a commissioner, has a different role, but the basic principle of judicial restraint remains the same. In a recent case on appeal from Jersey, the Privy Council said, "Naturally in Jersey, where the facts are decided by jurats, the commissioner retiring with jurats but not joining in the fact-finding process unless the jurats disagree, the facts are not summed up. But that cannot begin to justify the commissioner seeking to give the jurats the benefit of his analytical powers by way of his own extensive examination of the witnesses or indicating his thinking by the nature of his questions and comments. The judge then is a referee and not a player. And so it was that Sir Robin Dunn, who ended his career on the English Court of Appeal, wrote in his memoir, "It was not until I became a judge that I realized how dependent the bench is upon the bar." And that realization was no less accurate for being somewhat belated. Advocacy, the source of that dependency, insofar as it is an art at all, is a transient one. Even a transcript cannot capture the immediacy of its impact, assuming it has an impact upon its audience, the tribunal to whom it is properly addressed. You cannot, as yet another retired judge, Sir Peter Bristow, said in his memoirs, autobiography being an occupational hazard of judges who've hung up their wigs, you cannot find the advocacy skills in the books. You have to learn them from your betters and think them through for yourself as you go along. Dame Elizabeth Lane, the first woman to be appointed to the High Court bench in England, in hers identified 4 pillars of advocacy, which can be summarised as good health, good temper, good voice, and last but by no means least, good luck. Some adopt more subtle, even suspect techniques. The same Peter Bristow recalled, "In our chambers we kept a drawer full of old school and club and regimental ties. Should we, for example, deploy service, club, or old school tie?" Well, this anachronistic advice is of limited utility unless the advocate was appearing unrobed before a judge, of no utility when he appeared in full legal fig before a jury. There are no old school bands, and equally utterly useless for the female advocate. George Carman, the so-called Silver Fox, certainly had Dame Elizabeth's fourth desideratum. In no less than 3 of his major forensic triumphs, his case for the defence was rescued by the adventitious, or so one must assume, arrival of a critical piece of evidence midway through or even just before the end of the trial. In 2 of them, he established that television journalist Janie Allen and television soap star Gillian Tailforth, who each sued in the respective stories of exotic sexual activity, were far from Vestal virgins. I must declare an interest as the unsuccessful counsel for the plaintiff in the latter. In the 3rd, he established that Jonathan Aitken MP, who defended a claim that when a minister, he'd allowed his bill at the Ritz Hotel in Paris to be paid by rich Arabs with whom he was dealing, on the basis that the bill had actually been paid at reception by his wife, was guilty of perjury, since last-minute evidence from British Airways showed that at the material time his wife had actually been in Switzerland, of which judicial notice could be taken that Paris is not the capital city. Yet other advocates rise to the top by techniques that appear counterproductive. Lord Devlin's account of the trial over which he presided of Dr. John Bodkin Adams, accused but acquitted of murdering his patients in anticipation of a legacy, contains this cameo description of leading counsel of the prosecution. His disagreeableness was so pervasive, his persistence so interminable, the obstructions he manned so far-flung, his objective so apparently insignificant, that sooner or later you were bound to ask whether the cane was worth the candle, and if you asked yourself that, you were finished. This did not, however, impede the career of the object of judicial derision, Sir Reginald Manningham Buller, immortalised by journalist Bernard Levin as Sir Reginald Bullying Manor, who held in succession both law offices of the Crown, ascended to the Woolsack, and ended his professional life as a Lord of Appeal in Ordinary with the title Viscount Dillon. How much influence advocates in fact have on the outcome of cases is not capable of exact measurement. According to Alan Passerson in his seminal study of how judgments have been and are reached in our Court of Final Appeal, a number of his interviews in the ranks of counsel were sceptical as to how often in the final court advocacy had a determinative effect on the ultimate outcome of appeals, whereas the law lords and justices were in general rather more positive as to the impact of good advocacy, as the author put it, fortunately, for were it not so, many clients would be paying substantial fees to no purpose. In a consumer protection case involving Torfaen Borough County Council, brought against a company for selling food past its sell-by date, where the Supreme Court was deprived of argument on both sides of the bar, Lord Toulson commented in his leading judgment, the company was not represented on hearing the appeal. The reasons are understandable, but the result is unfortunate. In these circumstances, the court asked a member of its legal staff to prepare a note of points which might have been made on the behalf of the company. Nonetheless, it is still unfortunate that the court did not have the benefit of argument from both sides. If the size of the contribution of the advocate to the resolution of civil cases may be debatable, it is all but dispositive in criminal cases with a lay, not legal tribunal of fact, magistrate or jury. Lord Judge, the recently retired Lord Chief Justice of England and Wales, said in his Calisher lecture, the administration of justice depends on the quality of advocacy deployed on each side. The jury will do its conscientious best, the judge will make the decisions and give the directions believed by him to be appropriate, but the analysis of each side's case and all the evidence and its importance to the case so as to enable both judge and jury to exercise their own responsibilities depends upon high-quality advocacy. And we are not discussing some disembodied theory. This is the day-to-day stuff of reality. Poor quality advocacy by either side simply increases the prospects of the guilty being acquitted or the innocent being convicted. In the process of adversarial trial before a jury, it is really as stark and simple as that. And as Lord Pannick put it in the speech I've already referred to, the work of advocates on legal aid makes an essential contribution to the administration of justice, defending the innocent and validating the conviction of the guilty. Now, given that advocates have so vital a role to play, it's imperative that they are not free to pick and choose when to play it. In May of 2012, the Legal Services Board, the legal regulator's own regulator, ever enthusiastic to bend the bow its novel powers, commissioned 2 academics to analyse the impact on the market of the cab rank rule, by which barristers are, in broad terms, obliged, subject to availability, adequacy of expertise and absence of conflict of interest, to represent any person who calls upon their services, however distasteful that person's character or cause. Nevertheless, in their report a year later, the academics concluded, the logic of our report argues that the rule serves no clear purpose, while it can be lauded as a professional principle enshrining virtuous values, as a rule it is redundant. They based themselves first on pure economic literature, which they described as scant and as very sparse and ultimately not very illuminating. Second, on interviews with so-called stakeholders, whose testimony was given in exchange for a guarantee of anonymity. And third, on sundry blogs and tweets. This may seem to you a fragile foundation on which to recommend abolition of a professional rule which dates back several centuries, but this in no way deterred the authors. There were 3 main points of suggested substance argued by them against the rule's retention. First, that other providers of legal services are not subject to it, so why should the bar be? Secondly, the rule's not been enforced and so is meaningless. And third, that one of its purported rationales is devoid of force, since there's no real problem with barristers being associated with their clients and so being dissuaded from providing immediate representation to those whose cases do not, for whatever reason, engage immediate or indeed any sympathy. As the first, the fact that others providers of legal services do not adopt the highest standard of conduct can surely not be a reason for abolishing the application of the rule to the bar which supports its retention. If anything, it's an argument for application of the rule to those other providers where justice is at stake, to enshrine the lowest common denominator in the practices of all branches of the legal professions is not the most obvious way to promote the rule of law. As to the second, the assertion that because there's no evidence it's ever been the subject of enforcement proceedings is likewise a strange piece of reasoning. The fact that proceedings have not been brought to enforce any rule does not mean it has no effect on conduct. Indeed, quite the contrary conclusion will often flow, namely that the rule is efficacious and does in fact guide conduct. And even if it were the case that the rule could be violated without redress, this would not nullify or reduce its value. The rule contains an important statement of principle about the aspirations of the bar and the values which it and indeed society seeks to pursue. And as to the third, one of the greatest attributes of the rule is the fact that it serves the public interest in ensuring that all can obtain legal representation. This is not something which is interests of the bar itself, but is crucial in ensuring that a potential client, plaintiff, defendant, or accused will obtain access to all those at the bar who are competent to handle his or her case. There is, contrary to the academic's premise, a real and present-day problem of counsel being associated wrongly with the cause that they pursue for their clients. In 2012, 2 Asian barristers withdrew from the trial of a group of Asian men accused of running a paedophile ring, referred to in the Rochdale grooming trial, after they were intimidated and physically assaulted at the start of the case by far-right demonstrators outside the Liverpool Crown Court. Abroad, the Delhi rape case and the Mumbai terrorist survivor case demonstrate yet further the difficulties that are faced by defendants in jurisdictions where representation of a client suggests association with that client, with the consequences that lawyers for those charged with such serious offences cannot easily be found. Certainly the judiciary appeared to be in no doubt about the cab ranks rule's continued vitality. In Rondell and Worsley in 1969, Lord Reid, in upholding the barrister's traditional immunity from claims of negligence, said about the position and duties of a barrister or advocate appearing in court on behalf of a client, it's long been recognised that no counsel is entitled to refuse to act in a sphere in which he practises and on being attended a proper fee for any person, However unpopular and even offensive his or her opinions may be, it's essential that duty must be continued. Justice cannot be done and cannot be seen to be done otherwise. And in 2002, in Arthur Hall and Simmons, where the same barrister's immunity was overturned, Lord Hobhouse said of the rule, "It is in fact a fundamental and essential part of a liberal legal system. Even the most unpopular and antisocial are entitled to legal representation and the proper protection of proper legal procedures. The European Convention confirms such rights." And the case of Crown against Ulke, the Lord Chief Justice, Lord Judge, again stressed the importance of the rule, saying that while it had importance in civil proceedings, and I quote, "it has so with yet greater emphasis in criminal proceedings." The rule is not just an English legal curiosity. As was observed by Mr. Justice Brennan in the High Court of Australia, if access to legal representation before the courts were dependent on counsel's predilections as the acceptability of the cause or the munificence of the client, it would be difficult to bring unpopular causes to court, and the profession would become the puppet of the powerful. And Sir Sidney Kentridge, speaking of his experience of acting for opponents of the apartheid regime, expressed the importance of the rule in characteristically eloquent and practical terms. The rule, he says, also ensures the independence of the advocate is generally recognised even by the public at large. This may seem pusillanimous. Why should we care what anyone thinks of us? If we all had the courage of an Erskine or a Clarence Darrow, we would not require that sort of protection. But I assure you that for ordinary mortals, the support of this professional tradition can be very comforting indeed. While Sir Sidney is himself no ordinary mortal, but fit to be ranked with those to whom he modestly declines to compare himself, his observation lose nothing in pertinence because of that. So was as explained by Lord Bingham in his chapter on the fair trial in his book on the rule of law, scarcely less important than an independent judiciary as an independent legal profession, fearless in its representation of those who cannot represent themselves, however unpopular or distasteful their cause may be. The academic's analysis appears oblivious to the fact the legal profession, while it inhabits a market, is not only a participant in a market, and mercifully the report has, at any rate for now, disappeared in the oubliette of history. Judges themselves are by tradition and training expected to suppress, so far as possible, their personal political predilections when ruling on cases that come before them. But over the last year, several members of the Supreme Court have yielded to the temptation of expressing their views on a topic of extreme sensitivity, the extent to which the court should defer to the Strasbourg Court's interpretation of the European Convention on Human Rights in applying those of its key provisions that have been incorporated into the domestic law by the Human Rights Act of 1998. The issue has achieved salience over a range of cases, including the exclusive use of hearsay evidence to achieve a conviction, the rights of prisoners to vote, and whole life sentences. Advocates, by contrast, do not enjoy even such limited license in their professional role. Their beliefs are irrelevant to the arguments they present. Indeed, for an advocate to state to the court his or her belief is a solecism. Advocates neutrally submit. Such convictions they may have are parked outside the doors of the court, and their independence is in that sense, at any rate, of a purer variety than that of the judges. But is the advocate's devotion to a client's cause an unqualified benefit? In a speech last year, the Dean of the Oxford Law Faculty explained to an audience in St. Petersburg, we have to focus on dispute resolution because of the way in which the common laws developed over centuries through the decisions of judges in trials and appeals. But he added provocatively, there are drawbacks to a common law legal education, even to a good one. We never put this on our university publicity material, but let's face the facts. We teach students how to make bad arguments sound plausible. We equip students to become part of an industry in which they can charge high fees for services in support of claims that should not be brought, and in making defences against claims that should not be resisted. This form of education supports the rule of law, But the rule of law is not altogether a good thing, and supplied an alleged example: if a murderer has a good defence lawyer and a fair trial, the lawyer may prevent justice from being done, while referring the very same sentence by way of decanal paradox to the counter case: yet our country is worse off if a murderer cannot get a good lawyer. I would describe the Dean's analysis as misguided, for intrinsic to it is a sense of omniscience, which, while it may be understandable in academic, is alien to practitioner. It confuses hindsight with foresight. It assumes that even before a case has even been argued, the answer to it is certain. And yet it is for the judge, not the lawyer, to provide that answer. Norman Birkett, one of the preeminent counsel in the golden age of advocacy, in his famous face-to-face television interview with John Freeman, said he'd not infrequently defended clients whom he believed to be guilty, but never one whom he knew to be so. In a democracy subject to the rule of law, it is no business of counsel to judge his client. As Baron Bramall once observed, a client is entitled to say to his counsel, "I want your advocacy, not your judgment. I prefer that of the court." And to the Dean of the Oxford Law School, I would make the respectful rejoinder: the rule of law is altogether a good thing, and the fact that in litigation the right result is not always achieved does not make it less so. Advocates, even judges, are only human. But whatever techniques they deploy, how far should advocates go in their desire to promote their clients' interests? The parents of the murdered 13-year-old Millie Dowler had their own sex lives subjected to prolonged scrutiny by defence counsel for Livy Belfield, ultimately convicted of Millie's murder. Domestic goddess so-called Nigella Lawson, a prosecution witness in the trial of the Grillo sisters, accused of defrauding her former husband Charles Saatchi, was accused of being a habitual user of drugs by the sisters' defence counsel to sustain a line of argument that she'd licensed such payments from his bank account as a price for their silence. Prosecutors are under a professional obligation not to seek conviction at any cost, but it may be that a similar restraint should be imposed on defence counsel rather than they should enjoy, subject only to control by the court, what Nigella's brother, the prominent journalist Dominic Lawson, described as an unchecked destructive licence. The degree to which the court's control is effective is itself controversial. Judge Robin Johnson, who'd reversed an earlier ruling to exclude evidence about Miss Lawson's alleged drug casing, was compelled to abort questions by counsel for Francesca Giller when she asked Miss Lawson whether she'd received a Mother's Day card with a spliff attached to it and the words "to enjoy later." Only then did he give a direction: "That ends your cross-examination. I'm not having any more. You have exhausted my patience," which is not an entirely principled or satisfactory safeguard. In the case of Faruqi, a terrorist case, the conviction of Mr. Faruqi and his co-accused were challenged last year on the basis of flagrant misconduct and alleged professional incompetence of Mr. Faruqi's advocate. In stressing that the trial process is not a game, the Court of Appeal emphasised as well that the advocate is not the client's mouthpiece. In short, the advocate's bound to advance the defendant's case on the basis of what his clients tell him is the truth, but say for well-established principles, the advocate and the advocate alone remains responsible for the forensic decisions and strategies. That is the foundation of the right to appear as an advocate, with the privileges and responsibilities of an advocate, and as an advocate burdened with twin responsibilities, both to the client and to the court. Faruqi then emphasised the well-known principle that lawyers' duties to the court may conflict with duties owed by the lawyers to their clients, and that the reconciliation of that conflict is also well known. To quote again from Chief Justice Mason in the Australian case of Generelli and Wraith, "It's not that a barrister's duty to the court creates such a conflict with his duty that the dividing line is unclear. The duty to the court is paramount, even if the client gives instructions to the contrary." And this may go so far as meaning that if a client, the other side in a case is unrepresented, client has an obligation to draw the court's attention to what the other side might have said. In the consumer protection case, which I've already referred, Lord Toulson mentioned the note prepared by legal staff had been disclosed to counsel of the local authority and added that Mr. Kirk, who was that counsel, himself invited the court to consider those points which we would have regarded as fairly capable of argument if he had been instructed on the other side. This was, said Lord Toulson, in the best tradition of the bar, and we believe it's enabled us fairly to evaluate all the arguments. It's always been necessary to ensure that only those who enjoy the privileges of advocacy deserve it. And historically, the bar has always been sanctioned for misconduct imposed by judges of the High Court, acting as visitors to the Inns of Court. Nonetheless, a sea change occurred with the coming into effect of the Legal Services Act of 2007, which substantially reformed the provision of legal services in England and Wales. At its heart were 8 regulatory objectives, which included supporting the constitutional principle of the rule of law and promoting and maintaining adherence to the professional principles, which themselves required that authorised persons should maintain proper standards of work. Part 2 established the Legal Services Board, whose domain extended to oversight, amongst others, of the Bar Standards Board, to whom the Bar Council had delegated its own regulatory functions. The Legal Services Board determined to drive forward a quality assurance scheme for advocates, so-called QASA. There were no less than 4 rounds of consultation and commissioning of further reports. The mountains laboured and produced not so much Horace's ridiculous mouse, but an animal of an entirely different nature, an evaluation scheme by the judges for all advocates to be introduced in stages, with the criminal bar being first in line. Market forces were no longer deemed sufficient to weed out the incompetent, nor the acquisition of points for continuing professional development, a euphemism if ever there was one, to improve them. It's unsurprising the bar should challenge the scheme, and no less surprising the challenge has at any rate to date been unsuccessful, given the support of the majority of the senior judiciary. The arguments that were advanced was that the introduction of QASA would create the perception of a relationship of dependence between the advocate and the judge. The judges might hesitate conscientiously to criticise for fear of being sued, and the advocate, for his part, be unwilling to jeopardise his chances of favourable references from the judge. The Administrative Court has rejected all those arguments, while recognising expressly that the independence and impartiality of the criminal bar, both prosecutor and defence, enshrined, and I quote, values to the great advantage of the rule of law in this country, they considered implicitly that QASA promoted rather than impaired it. Let me now try to weave the threads of this lecture into something that more closely resembles a seamless robe than a patchwork quilt, and ally it to Lord MacDermott's own concern about protection from power. For coupled with the albeit postponed reduction in legal aid is the imminent curtailment of judicial review through the vehicle of the Criminal Justice and Courts Bill currently before the Westminster Parliament. Since judicial review is concerned with ensuring that government is itself not guilty of abuse or misuse of power, it's never been popular with governments of whatever political complexion. While the Lord Chancellor was himself a judge, he could and did defend the judiciary against attack. The present incumbent, a politician, not a lawyer, has no judicial role. Indeed, the title Lord Chancellor, which the Secretary for Justice currently enjoyed, now has no greater substance than the smile on Lewis Carroll's Cheshire Cat, given indeed its significant differences in terms of function with that of the office holders prior to the coming into effect of the Constitutional Reform Act of 2005, the title or name might itself be said to constitute a misleading statement, as well past its sell-by date. But though complaints about judicial overreach by ministers who've been the objects of unfavourable judgments are legion, the target of the Lord Chancellor has been the advocates, not the judges. In his foreword, his response to a consultation on judicial review, he wrote, "I believe in protecting judicial review as a check on unlawful executive action, but I'm equally clear it should not be used to act as a brake on growth. In my view, judicial review has extended far beyond its original concept and too often cases are pursued as a campaigning tool or simply to delay legitimate proposals. That is bad for the economy and the taxpayer, and also bad for public confidence in the justice system. Acting in the substantive part of the document, the government's view it's a better way to deliver its policy is through a strong package of financial reforms to limit the pursuit of weak claims, especially not only by aiming to deprive parties and interveners of protective cost orders unless permission has been granted. The devil is all in the detail. It amounts, in short, to death by 1,000 cuts. But what is notable is that the case against what are perceived to be extravagant applications for judicial review are couched in economic and not in constitutional terms. And yet the Lord Chancellor had another relevant obligation under the Act of 2005, which stated in its first section, this Act does not adversely affect the existing constitutional principle of the rule of law or the Lord Chancellor's existing constitutional role in relation to that principle. And the same monocular approach informed the Lord Chancellor's explanation for the postponement of his legal aid reforms. He said, I wanted to do what I could to ease their effect on lawyers. But the Lord Chancellor has, with the greatest respect, wrongly focused on the singer, not the song. In the words of Lord Henry, in Oscar Wilde's picture of Dorian Gray, his department appears to know the price of everything, but the value of nothing. For these two streams of reforms, curtailment of legal aid and of judicial review, are interrelated, not distinct. As Lord Folkes, Queen's Counsel, said in the House of Lords debate on the former, what is at stake is not just the standard of living of lawyers, but the ability for members of the public to obtain competent representation when facing criminal charges, the consequences of marital breakdown, abuse of power by public authorities, threats of repossession of their homes, or deprivation of contact with children or grandchildren. The cuts affect the most vulnerable asylum seekers, prisoners, the mentally ill. And Lord Neuberger, President of the Supreme Court, added this melancholy reflection, cut-price litigation leads to unrepresented litigants and worse lawyers. Direct consequences are the elongation of hearings and the increase in the cost of the courts themselves, but more importantly are the indirect consequences, the risk of judicial error and hence of injustice. It can be said of the bar, not only that it presents arguments better than litigants in person, an under-ambitious aspiration, not certainly that it does it perfectly, but rather, as was said of James Bond in the Carly Simon lyric, nobody does it better. In my thesis is that the fulfillment of the forensic function by a profession, educated, conscious of its plural duties and the balance to be struck between them, subject to proper education, monitoring, and where necessary, discipline, and ever faithful to its fundamental principle, the cab rank rule, is necessary for the prevention of injustice and the protection of the rule of law. The many changes to which the Bar of England and Wales has been subjected over the last 20 years may appear to deflect attention from some of its core values. An increasing number of qualified barristers in an age of austerity prefer the security offered in the employed sector. I do not deprecate such choice, but as Sir Ivan Lawrence, one of the diminishing number of lawyers active both in the Commons and the Court, said, the independence of the self-employed lawyer, owing allegiance to his client, not to an employer telling him what is in the best interest of the firm, is of particular importance to the integrity of the justice system. An independence put at particular risk if the employer is the state. The vision said by skeptics to be prevalent in the Ministry of Justice of a future where a Crown prosecution service is confronted by a state defender system is not one calculated to inspire public confidence. And concurrently, the emphasis on marketing and branding of sets of chambers as if they were de facto, if not de jure, partnerships rather than association of independent practitioners, the imminent ability now to convert chambers into partnerships and even to become subsumed in commercial entities, as well as the deliberate withholding of labour, suggests that paradoxically barristers are in danger of adopting the features both of business and of trade unions. And the future possibility for a barrister to practice as a limited company with consequent tax and limited liability advantages, and even with his or her spouse as shareholders, has been advertised in a recent brochure by a firm of chartered accountants. This, if nothing else, would add new hazards to conscious uncoupling. A trial is not, as was said in the Faruqi case, a game, but nonetheless, Brantland Bryce, the American sports journalist, penned a quatrain which is usually attributed to cricket, in fact refers to baseball, but would be equally appropriate to advocacy. For when the one great scorer comes to write against your name, he marks not that you won or lost, but how you played the game. A trade, a profession, or a vocation. That is, as it always was, the choice for the bar. On how it exercises that choice will depend, in part, the future of the rule of law itself.